6:09, Mr. Burton.
Good
Give
deal.
the invitation, please.
Will you stand and join me in prayer? Father in heaven, we thank you for this day. We thank you especially for this time we can meet together and do the business for the Cherokee people. We ask now that you'd bless each one here today. Bless our leader and be with especially our national leaders. Be with the Kennedy family and lost of this loved one. Forgive us for our sin. In Jesus' name I pray. Amen.
Thank you, Mr. Burton. Roll call.
Meredith Rayleigh.
Here.
Joel England. Gilton Baker.
Here.
Jack Baker.
Here.
Harley Buzzard.
Here.
Julia Coates. Bradley Cobb. Joe Crittenden.
Here.
Jody Fishinghawk. Here. Janelle Fulbright. Don Garvin. Chuck Hoskin Jr.
Here.
China Glory Jordan. Curtis Snell. Chris Stubbs.
Here.
David Thornton. Kara Cowan Watts. We have a quorum.
We have a quorum, just barely. The purpose of our meeting today is a reconvene meeting from the August 11th rules is for the presentation of this Cherokee Nation Waste Management for discussion and possible action. I'm not sure if any action actually can be taken yet because we haven't received approval from the EPA. Is that correct, Todd? As far as you know?
And as far as I know, have y'all, EPA acted or ETC has acted?
The ETC meeting was Tuesday, and they tabled the discussion on that, and they're going to have a special meeting the 10th of next month to discuss that again. And
Okay.
it'll be on the agenda. They wanted a little more information, but it'll be the 10th of next month.
Okay, thank you.
Madam Chairman, I would recommend that we hear further from CMB and attorneys from Hall Estill as to any liability issues. We still, the EPC hasn't give a license yet to Cherokee Nation Waste Management. Cherokee Nation Waste Management still does not have a board. They may have a board and they have some nominations approved by the end of the day. But until such time as that is, I don't believe it's very imperative that we take an action in this special rules.
All right, thank you. Who is here to present from CNB? Probably we're mainly discussing the legal issues involved.
We've lost our quorum. Let me go get.
Who did we lose?
Joe.
Oh, okay.
We're not taking action.
Yeah, there's no.
You can go ahead and give a presentation as long as you don't take any action. Okay.
Jim, are you
Yeah,
here
Madam
to?
Chairman, Rob Doherty from Hall Estill, as you know, has authored the memo that you've seen. He has graciously agreed to spend as much time or as little time as you like hearing all that boil down. So if you don't mind, I'd like to let Rob.
Okay. Mr. Jordan, you want to come forward?
Yeah.
I'm not glad to. Thank you. Yeah. Come on in. Yeah, as you said, I'm Rob Doherty. I'm with Hall Estill. Hopefully you guys have seen my memo.
Yes.
It's mine. I mean, Michael certainly helped us. I've got Michael Graves here with me as well. He's one of our senior environmental partners at Hall Estill. But I thought what I could do, and I was telling Jim on the way out here, is kind of, with the memo, I mean, kind of give you the bottom line on the memo and break down these liability issues kind of one, in three tiers, essentially. That I think will maybe clarify some things based on the last meeting. I heard a lot of things being thrown around, so maybe I can clarify that for you. I think, really, if you talk about three tiers or three basic liability concerns, the first one I would talk about would be the nation being held directly liable as the owner of the land or as the former operator. Now, we've talked about it, and it's in the memo extensively, that under the environmental laws, the primary environmental statutes are, of course, CERCLA and RCRA. Owners of landfills, even if they're not the operator, can be held directly liable. Former operators certainly can be held directly liable as contributor to if there's an environmental issue out there. And so the nation has that liability already, sort of regardless of who owns CNWM. So that's one layer.
Rob, can you hold just a second?
Yeah,
Mr. Baker?
Technical question.
absolutely.
Are we the owners of the landfill when it's in trust, the federal government holds it in trust for us?
You know, I think, I guess I don't, we didn't research that issue, but I would say that you are. I mean, you control the land, you own and control the land.
Well,
I don't
I'm
know.
not sure we own it. I mean, it's held by the federal government in trust for the Cherokees.
Right, and Cherokees are the beneficiary of the trust. You know, we haven't actually been asked to look at that question specifically. I'm sure we could get a quick answer from our Indian law group on that. I would suspect the answer is that it is. The federal government holds the land for the tribe, but they're the beneficiary. They have all incidents of ownership, benefits and burdens of ownership would be, you know, what I would say. Now, you know, have we researched that specifically? No, we haven't, but we certainly can.
May I interrupt again, Mr. Henry?
And that brings up a point, and we would happily give the deed to the attorney and to Diane when she gets here. But there's also a question that you know, when I actually looked at the deed, that deals with the Cherokee Nation and it being organized under the Indian Reorganization Act, and you know, you know, I know we haven't organized under the Indian Reorganization Act. So when you look at that, also look at that aspect of it, because that, you know, that just kind of sent up a question in my mind.
Okay. Well, I guess I guess the reason we haven't looked at that specifically, because that doesn't really relate to the question, and our primary focus has been, you know, what is really the difference between CNB owning CNWM and the nation owning CNWM? So, I mean, I guess that question plays in, but it's really going to be the same regardless of whether CNB owns CNWM, if that makes sense. So, you know, my point about that first level is that essentially the nation already has that. That doesn't change regardless of who owns CNWM. The second piece that we go into in detail in the memo.
Wait a moment, Rob.
Oh, yeah, take your time.
Mr. Baker, did you want him to research that question?
I would like
for
to
you?
know, yes.
Okay, sure. We can get an answer to that. We'll supplement that, no problem. Be glad to do that.
Thank you. Continue.
Sure. The second liability area of concern is the liability of the parent of CNWM. That's something we've talked about a lot, or you've talked about a lot. And really, you can break that component down into two things. You talk about direct liability of the parent versus indirect liability. Direct liability, the case that's cited in the memo is a U.S. v. Best Foods. It's a Supreme Court case, fairly recent, that really tackles this issue directly in the context of environmental liability. And the rule is basically a parent can always be held liable as a direct participant in a violation that gives rise to an environmental issue. And that's what the court found in the Best Foods case. The parent had a employee that was on its payroll that was making decisions about environmental issues for the sub, and therefore the parent was found liable. That liability could occur whether the nation is the grandparent entity or the parent entity. It's the same thing. The test is just simply whether or not the nation's actions, you know, rise to the level that they're directly involved in whatever action gives rise to the liability. So, again, that applies really either way. And that would apply to CNB as an owner, any parent of a sub, and it would apply, that kind of analysis would go into play for the nation with respect to CNB as the owner of CNB, for example. The other piece, the indirect liability, you know, that's where we get into the piercing the veil type claims that have been discussed.
Rob, while you're paused there, Mr. Hembry?
I'm sorry. The one question that I would have is the liability memorandum that you did for Cherokee Nation businesses, would the same liability be for the board of directors of Cherokee Nation Waste Management? Is it the same on the same level as what CNB would have? Or, because, you know, later on today we're going to be, you know, talking about some possible board of directors, and I think we owe a due diligence to them to let them know, any liability potential as it come along. So if we gave them a copy of your memorandum, would it be the same level? Would the same questions apply, I guess?
The board for CNWM.
Yeah.
Yeah, and let me, that's a great question, and let me get to that. I guess the point I'm trying to make here is that this parent liability we're talking about on the second liability concern does not get to the directors and officers or council members. That's a whole separate deal. All we're talking about here, when we talk about piercing the corporate veil, that doctrine only holds owners liable for the actions of its sub. Of course, the owners in this case would be the nation and or CMB if CMB is the owner of CNWM. At this point, we're not talking about individual liability for officers and directors and council members. That is the third piece that I want to talk about. And what that is, if you're talking about an individual officer being held liable under CERCLA or RCRA or whatever other law, there's a difference between, the typical business officer and director versus a governmental official. And we've talked about this some, but essentially there's what's called the responsible corporate officer doctrine, which applies in the business world, and we think would apply to CNB as owner of CNWM, where directors and officers can be held personally liable under, if three standards are met, which is basically they have knowledge that a violation is occurring, they have the capacity to prevent or stop that violation from occurring, in whatever capacity they are in the corporation or business entity, and they fail to act, and that failure actually leads to the commission of the violation or the continuation of the violation. So those three factors have to be present for an individual board member or officer of a private entity to be held liable. Now, when you're talking about governmental officials, you guys, or any other officials of the nation, being held liable for individual acts, that doctrine actually doesn't apply. You get into what's called the public official immunity doctrine, which essentially says, and it's from court decisions, that the immunity of the governmental entity, in this case the nation, extends to its officers, directors, everybody, officials, and that's a much broader protection than private officers and directors enjoy. What you have is basically immunity with a few broad exceptions, and those exceptions that have been enunciated by court decisions are malicious, intentional conduct, acting outside the scope of your authority. Obviously, if you go do something you have no authority to do, you could subject yourself to personal liability. And then some other very narrow exceptions if there's a constitutional violation going on. It's called the ex parte Young doctrine we talk about in the memo. The court can order you to stop that behavior prospectively going forward. So those are really the only exceptions that are out there. And in fact, you can't even be held liable individually for your negligence as long as you're within the scope of your authority as a government official. So government officials do enjoy broader protection than business officers and directors. And that is the only thing that individuals as yourselves need to worry about. You don't need to worry about piercing the corporate veil or any of that stuff. It really just breaks down to your individual behavior and whether or not you cross one of those exceptions to governmental immunity, which is pretty hard to do. So, and that is all in the memo.
Anyone have any questions, comments for Mr. Doherty? Mr. Austin?
So suppose council member says something publicly that they want something done at the landfill, or they want the landfill to refrain from doing something. There's been no official action of the council to direct that. Of course, we're several steps removed from any control of the landfill, but suppose the landfill operator said, boy, that's a council member who just said that, I better do it. And it turns out that somehow gives rise to some liability through some omission or commission. Is the person who's initially sued going to come back and say, well, it's the council member who's shooting off at the mouth in the newspaper that caused me to do this? Is that too far-fetched, or is that within the realm of possibility? I know anyone can file anything, but
yeah,
is it safe to say that there'd be no basis for that claim?
Well, I think so. I mean, I think, first of all, that could occur whether or not CMB owns CWM or the nation does. But really, that type of claim, it would be that individual, you're right, the individual officer at the landfill would have to claim that he followed specific direction from tribal council member and that he, that was part of his job description to do that. I don't see it. Now, if the council member, went out there and was directly participating in that, obviously that goes beyond the scope of your position. It would have to be, you're going out there and you're actually making decisions that are, like bury these mysterious, 100 barrels of whatever it is way over here. It would have to be a case like that. As far as just him following some comment he made publicly, I'm not seeing it, Michael. No, and that would be, again, you don't have any authority to do that. He doesn't have any authority to respond to those comments. That'll be clear under the governmental documents of CNWM. He follows the direction of his board of directors, and we talked about that. Todd mentioned protecting the CNW board members, and that can be set up to do that. But essentially, that's who he answers to.
Mr. Embry?
We'll talk about fact scenarios. One fact scenario that I'll give you a hypothetical that I know the counselors, if they haven't been, they will be involved in, is that they talk to their constituents all the time. People come to them, they tell issue their concerns, etc. Let's say, for example, if someone comes up to one of these counselors and say, "Hey, look, you guys are doing, they're doing bad things down the landfill. They're taking in bad trash or trash they shouldn't have, they let them know, or it might be rumors, it might be fact. What liability would that expose to the council members if and when that kind of stuff happens?"
Yeah, you have to look at the governmental immunity that we just talked about, public official immunity doctrine, if you will. Really, I think in that case, one, you don't have actual knowledge of anything going on. Maybe you have some accusations, but the only way you could be held personally liable is if you did something intentional or malicious under these cases that we cite in here. So personal liability, if you don't even do anything on that, it's going to be, I don't see how you can be personally liable under that governmental immunity doctrine. Now, if there's some credible information, I'm sure you would just pass that on. I think that would be the extent of any duty you would have as a counselor. You pass that on to the people that are in charge of the landfill, and then you're of course protected. But again, personal liability, for you to be sued based on that, they would have to show that you did something malicious, intentional, and listening to a random phone call that comes in. I don't see how it could ever rise to that level, to be honest with you. So I don't see any liability there. Certainly as a council member, if it seems credible, you want to pass that on to whoever's in the CNWM board, and let them deal with it. And if you did that, there's literally no possible way you could be held liable based on that fact scenario.
Charleston, you still have the floor.
Nothing further, thank you.
Yes, Mr. Lori Jordan?
I've got to apologize. I was a little late this morning, and sir, I didn't catch your name.
Oh, I'm sorry. I'm Rob Doherty.
Okay.
With Hall Estill.
You're an attorney with
Hall Estill, yes, and my name's on the memo, or I actually put it in letter form, just a personal preference that I have.
And this would be one of the instruments that's been provided to us.
Mm-hmm.
And would that instrument be the letter dated August 3rd?
That's right.
And would that be the letter that's directed to Bob Huffman and Jim Carrington of Cherokee Nation Businesses and Diane Hammonds, Attorney General of the Cherokee Nation?
That's correct.
Have you provided a letter to us, the council, on your letterhead, giving us an opinion of the liability pertaining to the landfill?
No, I can, and that's not a problem. And we, again, this is not so much an opinion as a pretty big effort to lay out the law with respect to these various questions, and that's what this does. And we can do that. Again,
Mr. Daugherty, who paid for this opinion?
Well, I assume CNB is who will bill for it. That's who we're working with.
And CNB is the entity that's wanting to get rid of the landfill, right? So they have an interest in seeing that the landfill comes back to the nation,
Right.
and that's who you work for.
Well, technically, but let me
Now,
just say,
well, but now, not technically, that's who you work for.
well, that's correct, but what I would say to that is, it's a parent-sub relationship, and so technically, there's no conflict there, and then technically, we, of course, can't do anything that, we really can't take a position that would be terribly adverse to the nation. And
Well,
that's
let
not
me
been our
put you
intent to
in
do
this
so.
position.
Sure.
If you work for the tribal council, this body, would you not want the tribal council to have their own legal opinion directed to them from a competent attorney such as yourself,
Well, thank you.
where it directs to us what our liability is, and then you're on the hook to this body? You're not on the hook to CMB who paid you, you're on the hook to this body. Would that not be prudent of this body to consider getting their own legal opinion regarding the liability issue pertaining to the landfill?
Well, I would say, to that is that I would call that, a second opinion, if you will. And if certainly you got, if you feel that's prudent, that's up to you. But I guess what I'm trying to say is that this is not intended, never was, to be a one-sided document. And to me, I'll stand behind it. It lays out what the law is as of right now. And, we address it to Diane and Bob Huffman because it's a neutral memo. It's intended to be that way. And again, we don't have a real conflict working here because it's kind of like the Coke Zero commercials. I said to Jim on the way in. Legally, you guys are really one and the same as far as representing. But, we work for CNB. You're right. They're paying our bills. That's a fact.
Well, let's say you make a mistake in this opinion.
Mm-hmm.
And let's say later on, if we take the landfill back and we rely on this opinion, and this opinion turns out to be wrong, and we are sued, and we are all sued personally, and we're now looking for somebody else to sue so that we possibly won't have to shoulder the burden of maybe a $10 million judgment. Are you saying that even though this opinion's not to us, you're saying that Hall Estill would pay if they made a mistake to this tribal council, even though we're not named in this opinion?
Well, I think, we've addressed Diane Hammond as Attorney General of the nation, right? And you guys are part of the nation. But again, this memo is not wrong. It's not
You
wrong.
didn't answer my question.
Well, would we pay? First of all, the memo...
If you make an error,
Okay, well...
will your errors and omissions insurance cover this body when this opinion is not directed to this body?
Well, I think my answer to that would be yes. If that were to happen...
You think your errors and omissions insurance would pay when you've given an opinion to someone else and this body relied on it? Now be real careful when you answer this question.
I think when we give it to the Attorney General of the nation, that you guys benefit from that as part of the nation. You are part of the nation.
And you're telling me that your errors and omissions insurance wouldn't be looking for a hole to get in if there was a $10 million judgment and we're coming back looking at you. First thing they're going to say is, well, this is not directed to Chuck. This is not directed to Harley. This is not directed to Mr. Thornton. This is directed to Diane Hammonds. We have no liability for these people.
Right. Well, if there were a mistake in here, which there's not, I promise you there's not, that triggered some sort of liability, and you may claim it's a liability insurance company, sure, they would look for a loophole. That's what insurance companies do. But that would be a bogus one, because that would be like saying, we have an insured that's a corporation.
It may be proven to be a bogus one $1 million later out of our pocket when we've had to defend to try to get to the point to make your errors and omissions insurance pay. That's why I brought up last time that, folks, we need to take a prudent route. We need to talk about getting our own opinion. And just put that on ice for just a minute, getting that opinion. Let's talk about one other thing. You just said we would probably not be liable for liability concerning the landfill because they would answer to a board. Now, do we have a board in place for the CNWM?
I mean, I obviously assume that's going to happen by the time the closing occurs. I don't know the status of that, but that's part of the paperwork. I mean, CNWM takes over, they have to put a
Well,
board
if
in
we
place.
take it back and there's no board, basically, we're responsible for it at this point in time until we get a board in place. Would it not be more prudent to wait on a decision concerning the landfill until we have or see a complete board for CNWM? You're trying to give us back a company that doesn't have a board to give it direction. So where does it get its direction from? If there's no board, it's going to have to get its direction from the tribe. That makes the tribe liable for anything that happens down at the landfill.
Before Jordan, that was discussed when we first started. Mr. Hembry recommended that we take no action yet.
Okay.
Well, and I agree with you. I mean, a board should be in place at the time the closing occurs. Now, you know, I assume whatever approval is made will be of the agreement that's in place to make this transfer occur. In that agreement, I believe it already requires that. If it doesn't, we could certainly put in there specifically that closing will not occur until a board has been put in place. And that's, you know...
And I don't mean anything towards you personally or all the
I
other
don't take it
lawyers
that
in
way.
the back. Heck, I'm a lawyer, Chuck's a lawyer, Meredith's a lawyer. Lawyers like lawyers and lawyers don't like lawyers. You seem like a really nice fella.
Well, thanks.
But I don't want to worry about that this council or the next council has to worry that this letter was not directed to us. And since you seem to have a dog in the fight, so to speak, because you do represent CNB, nothing against CNB, but I still think that we need to consider, as a body, getting our own legal opinion. If nothing else, we need to get it from Todd before we make a decision. We need to have our own written opinion regarding liability concerning this landfill. It's all well and good for someone to stand up here and say you have no liability. Well, then my next question is, why are you trying to give it back if we have no liability? Well, it don't fit in with their business plan. Well, it's still a business, folks, and we were told, what, less than a year ago, that businesses need to be run by our business arm. Our business arm is CNB. We made the deal that they were going to run it. Now, all of a sudden, they're wanting to throw it back on us. There's some reason they want to throw it back on us, and I don't think that reason has ever been brought out to this body. And I don't think we're going to know the reason until it's right in our lap and it hits us in the face. This is just so premature to consider doing anything on this until, one, we see our liability insurance be brought down to a more reasonable level. Right now, I've looked at it. I think probably Chuck's looked at it, probably Meredith's looked at it, probably some of the rest of you've looked at it, and there's big problems with our errors and omissions insurance. Big problems. That needs to be addressed before we think about taking back this landfill. We need to get our own legal opinion. That needs to be addressed before we take back this landfill. We need to see that they've got a proper board in place that will be taking the reins of CN, whatever the LLC's name is, CNWM. We need to be sure that a proper board's in place. I mean, we're meeting and we're discussing, but it is all premature until we at least get those minimum 3 things in front of us so that we can look at them and then make an informed decision. Don't go into this blindly. This is probably one of the biggest actions you're fixing to take, and we sure need to get at least a minimum of those 3 things in front of us before we make a decision. I know that Mr. Crittenden has, in addition to those 3 unanswered questions, he has questions about whether everything has been corrected down there so that we might want to consider taking it back. So there's a 4th very important area that has not been answered. And I would make a motion at this point that we adjourn this meeting and put this off for a 2-month period of time until we can get those things in place, and then come back and at least have some more information before we take an important a vote of this magnitude by this body needs more information. I would make a motion that we adjourn at this time.
Second.
I have a just point of clarification. Is the motion to adjourn coupled with some direction to Mr. Hembry or is it?
I would, in addition to that motion, I would ask that we be given our own legal opinion directed to us, and that it go through Mr. Hembry's office, and that he be allowed on behalf of this body to procure whoever he needs to assist him in that opinion, an expert in this area.
Second.
Madam Speaker, I don't
Call for the
necessarily,
question. Call for the question. I mean no disrespect to
I
the-
believe I have the second, and I was next on the list, so I would be guaranteed that second. So,
I was second on the list. I seconded Tina's.
I think when I
no, I
amended
was
my
already
motion.
Madam Chair,
She's second.
thank you, Madam Chair. So, I'm okay that, you know, of course, Attorney Hembry represents us, and I think that would be prudent. But there's no budget allocation for that additional legal fees, and that's an open-ended checkbook, which I don't agree with. So,
Mr. Evans, can you clear that up, please? In regard to the budget question that she brought forward.
Do we have an estimate of how much
Well,
we're talking about?
well, maybe I can
Okay,
answer
Mr.
that.
Hembry.
From time to time, you know, as I've represented the council, I've engaged the assistance of outside attorneys, obviously with the, in the past it was the chairman of executive finance, but now it's at the permission of the speaker. Obviously, I know the budget constraints, and what I would need to do is just find out how much it's going to cost and who's available. At the very least, I have a duty to you to provide an opinion to the best of my ability that I have resources for about your liability, and I'm going to do that. I believe, and I don't need a directive to do that. I'm going to do that because I'm your attorney. But I will, at the request of the council, locate an independent outside environmental law expert at a reasonable cost to provide an opinion.
I can't accept that as a friendly amendment with the terms reasonable cost, because I don't know who determines what's reasonable. That's
Mr. Hembry,
A reasonable.
Yeah, okay.
Mr. Hembry.
If Todd can give me a reasonable estimate as to how much this is going to cost.
This is from
and
a CPA,
huh,
reasonable, from a lawyer.
Can I use those two words together?
Conservative CPA,
Okay.
from a liberal.
If he gives me an
Mr.
estimate,
Evans, you have the floor.
if I can obtain an estimate from Mr. Hembry, and I determine that cannot be accommodated within our contract service budget for this year, then I'll notify the chair and co-chair of the finance and the speaker
That'd be
immediately.
great.
But I suspect that our contract service budget, up to this point of this year, could accommodate that legal opinion.
Thank you, Mr. Evans.
Point of information, I guess.
Sure.
I was late, so my apologies for not knowing the answer to this question. Has this already been defeated earlier in this meeting for outside counsel, this question of outside counsel?
In this meeting, today's meeting,
Or maybe, I think
Previous
either
meeting.
this one or the one we recessed from.
yes, it was defeated, that's correct.
I'm not going to accept it, and it needs to be voted on separately.
That's fine. Okay, Ms.
She
Gloria
doesn't
Gordon.
want a point of order. She doesn't want to second my motion. I want, and correct me if I'm wrong, I can go forward with my motion. If somebody else seconds it, I can go ahead and take a vote on it.
Friendly amendment.
Mr. Hembry?
All right, following the procedure here. We have what is called a compound motion, a motion to adjourn for 2 months, and a motion for legal opinion. Ms. Cowan Watts says I want to take votes on that separately. That is called division of the question. Any member of the body can move to division of the question. Okay, so and that's under Robert's Rules of Order. So you would take a vote, you would take 2 votes, one to adjourn for 2 months and one for a legal opinion.
Okay, so discussion time now?
Yeah.
That was offered as a friendly amendment. I properly seconded the main motion as it stood. The person who made the motion accepted the friendly amendment. Myself as the second did not. So therefore, the friendly amendment's not accepted, and it would have to be amendment to the main motion, which was the motion to adjourn.
Or someone seconding, she's withdrawing her second if someone else from the body.
I am not
seconds.
withdrawing my second.
Just a point of clarification.
You're not,
No, I don't. She's never done that before.
Okay.
Yeah.
But you called for a division, which is the same thing.
No, I just offered that we could vote on it separately, which means.
I'll make it real easy. I withdraw my whole motion.
Hold on. Mr. Baker,
Well, mine was, if she's withdrawing the motion, because mine was point of order, that we already voted down the additional legal counsel in this meeting.
hey,
I mean,
Mr.
and so therefore, we can't bring it up again.
We've got another hour.
Mr. Baker, you'll be finished?
Yes.
Okay, Mr. Hoskin?
Well, this may be moot at this point because she's withdrawing her motion, but I didn't understand her to be accepting a friendly amendment. I understood that her original motion, based on sort of the prelude, was that she wanted legal counsel in connection with the adjournment. I just wasn't clear on that, so I wanted to make sure. So I think that was her original motion, but I don't know if it's either here or there at this point because she's withdrawn it.
Mr. So?
Yeah, one thing I would request, Madam Speaker, is that whether or not Todd, when and if he does get the opportunity to provide us with his expert legal opinion, would be that included in that, if he would go and really clarify the liability, as we're calling it, that not only this council, when it took their current seats, but also any previous political figures or entities, their liability. Because at this point in time, I think that, we say that we're taking it back and all that kind of stuff, but it's always been ours. Do we own the land? Don't we own the land? And it's concerning to me that the council or previous councils didn't really understand the implications of this business that they were operating. And so I know from an environmental viewpoint, if you spend more time worrying about avoiding the liabilities, that's really not the right attitude to have when it comes to environmental practices. You should be best practices and all those types of things. And so, but we keep talking about we want to avoid this liability, but there was a point in time when we really have the liability because we approved, whether it's a board member of C&D or whether it's a board member of C&W. I mean, we really approve these individuals. We approve the budgets. So at what point in time are we just really scared about something that's already out there and we just weren't aware of it, and if we're kind of concerned about it, then how more can you protect yourself? That's what I want to find out.
Thank you,
Mr.
Chair.
Watts? Thank you, Mr. So.
Motion to adjourn.
Second.
Moved in second to adjourn. Any discussion?
Discussion.
Okay.
On a motion to adjourn, I think there is discussion, isn't there?
No.
Can't be
No, it's
discussion.
undebatable.
I'd like an opinion from Todd.
I'll have to look on our chart. I don't believe a motion to adjourn is debatable, though.
No, it isn't.
So if there's a motion to adjourn, you either vote
It is
it up or
not
down.
debatable.
Yeah.
For the 10th editions of Robert's Rules of Order newly revised.
Is not debatable?
Not debatable.
Are we adjourning for 2 months? I do, point of clarification, are we adjourning for 2 months?
We're adjourning until another meeting is decided separately from this, that the chair is willing to.
I can't hear you, I'm sorry.
It would be the same as anything. We're just adjourning, and if you decide we need an additional meeting, you would call it.
Right. All in favor of adjournment signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call. Yes, it's to adjourn.
Chuck Hoskin Jr.,
No.
China Gloria Jordan,
No.
Chris Soap,
Yes.
Curtis Snell,
Yes.
David Thornton,
No.
Tara Cowan Watts,
Yes.
Bill England,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Harley Buzzard,
Yes.
Julia Coates,
Yes.
Bradley Cobb, Joe Crittenden,
No.
Jody Fishinghawk,
No.
Meredith Fraley,
Yes.
Janelle Fulbright, Don Garvin.
Yes.
You have 9 yes and 6 no.
9 yes, 6 no, we are adjourned. Todd, I need to talk to you.
Meredith, I understand Todd is gonna proceed on with the legal